Good morning, Council. It's a wonderful day to be a Kansan, Rock Chalk Jayhawk. I know a lot of us stayed up late last night, so we appreciate everybody being here this morning for our April panel of the Kansas Court of Appeals. I think I know both of you, but my name is David Bruns, and I've been on the Kansas Court of Appeals since 2011, and before that I was a Shawnee County District Court judge. And it is a pleasure today for me to be serving with Judge Amy Klein, who was appointed to our court in 2020. And before that was in private practice in Wichita. And also it's an honor to be serving with Senior Judge James Burgess, who's been with our court for quite a few years now as a senior judge. I don't know exactly what year, but before that he was a Sedgwick County District Court judge and was in private practice in Wichita prior to that as well. And I'm happy to report that each member of this panel has at least one degree from the University of Kansas. So our first case this morning is Prince versus Kansas Department of Labor, which is taking a long and winding trail to be with us again, with the Kansas Court of Appeals again. And we look forward to your arguments today. So if you would state your appearances, and if the appellant would let us know whether you have any time you'd like to reserve for rebuttal. As you know, each side has 15 minutes for arguments. So if you want to reserve some of your time, let me know that as well. So with that, would you state your appearances?
May it please the court, Danielle Davey on behalf of petitioner appellant Richard Prince Jr. And Your Honor, I would like to reserve 3 minutes for rebuttal.
That's fine.
If it please the court, Glenn Griffith appears on behalf of the Kansas Department of Labor.
Okay. With that, I'm not reading text about the game or anything. I'm going to set my watch and let me do that. And with that, Ms. Davey, you may begin.
Thank you, Your Honor. The issues before the court today are relatively narrow, dealing only with damages. But we requested argument in this case because, as Judge Bruns commented, this case has a long procedural history which informs the specific issues before the court today. Much of the factual history in this case is contained within the court's opinion in case 110182, which was filed in April of 2014. But in very brief summary, Mr. Prince was employed by the Kansas Department of Labor as a training coordinator in the Unemployment Division's contact center. In February of 2011, he received a one-paragraph letter from then Secretary Karen Brownlee indicating that his position had been moved. When he reported to work the following week, he was provided with a new position description, which reflected his position as administrative assistant. On March 28th of 2011, Mr. Prince received a memorandum which formally indicated for the first time that he had been removed from his previous position due to alleged performance deficiencies. Mr. Prince filed an appeal to the Civil Service Board alleging wrongful demotion. And then in July of 2011, Mr. Prince's employment was terminated as part of a reduction in force. The Department of Labor had opposed the Civil Service Board appeal, arguing that the action taken was not a demotion because despite the substantial changes in Mr. Prince's job duties, KDOL maintained his classification and pay grade, and they also objected to the timeliness of the appeal. In 2012, the Civil Service Board dismissed the appeal, finding that if a demotion had occurred, it was in February of 2011 when Mr. Prince received the original notice, and so the appeal was determined to be untimely. On judicial review, the district court reversed on the issue of timeliness and entered a judgment in favor of Mr. Prince. And then this court affirmed the district court on the timeliness issue, but reversed the judgment and remanded the case back to the Civil Service Board for an evidentiary hearing. That hearing occurred in October 2017. Following 2 days of evidence, the board unanimously found that the employment action taken was a demotion, and quote, KDOL's actions were an attempt to deprive Mr. Prince of his due process protections under the Kansas Civil Service Act. As a result, the board ordered that Mr. Prince be reinstated at the same job classification and pay, in the same or similar position, and with the same or similar duties. And in addition, the board ordered wages and benefits from August 2011 to August 2012. The two issues before the court now are whether the board's order limiting the benefits portion of the damages award is supported by substantial competent evidence or is otherwise arbitrary and capricious. And two, whether a subsequent finding of the Civil Service Board that KDOL complied with the order for reinstatement is supported by substantial competent evidence or is otherwise arbitrary and capricious.
Ms. Davy, let me ask you a question that's somewhat procedural, but it could end up being substantive. It appears to me on the record we have two final orders to some extent. Are we to construe those two together? Do we disregard the first one and only look at the second? What is your position on that? And Mr. Griffin, I'll ask you that same question, so you might be prepared as well. Because I want to know exactly what it is that is being appealed from and what it is that we need to be interpreting.
Your Honor, I think the appeal at this point is from the second final order of the Civil Service Board. I think the court needs to take that in the context of the findings in the first order, because the first order really informs why the damages award was made, and the damages award comes from the first order. But the second order is more specific in terms of the board's findings, because there was a second judicial review action in 2018. And in that action, Judge Anderson remanded the matter back to the Civil Service Board for additional findings of fact, which is where we get the second final order out of the Civil Service Board. So I think the court needs to consider both, but the appeal at this point is coming from the second order.
Okay. And then again, just some kind of basic questions, but I think they probably go to the heart of this case, trying to get it resolved. What exactly is your client asking for at this time? Is he asking for extended benefits and extended lost pay up until today? Is he asking for one and not the other for a certain period of time? I know that because this has dragged on so long that he's employed now in Nebraska and has been for quite a while. So what exactly is your position as to what he's asking for and what period of time?
Yes, Your Honor, at hearing, what he asked for was 1 year of lost wages from August 2011 to August 2012, because in September of 2012, he did start some new employment that effectively mitigated his wage loss. So we only asked for 1 year of wage loss. However, the testimony at trial was that new employment in September of 2012 did not come with benefits, including health insurance or retirement, similar to capers that he had with his previous employment, vacation or sick leave, those kinds of benefits. And so we had asked at hearing for benefit accrual up through the date of hearing. We are not asking for that to continue to accrue through the present day, because Mr. Prince has started employment. He had started employment in, I think, October of 2017, just right before we had our Civil Service Board hearing that did come with benefits. And so he has now fully mitigated his losses.
So what would the cutoff be then for the benefits request?
Your Honor, what we had asked for was through the date of hearing, which was in October of 2017. So that was the accrual that we had asked for.
Okay, thank you.
And Your Honor, part of the issue with that is the Department of Labor has contested that continuing accrual through the date of hearing, really based on two, I think, misconceptions or misconstruals of the testimony. One, there was a finding by the board that Mr. Prince had already fully mitigated his wage loss because he was making substantially more in his subsequent employment. That's inaccurate based on the record, because the record at hearing, Mr. Prince was asked what his current salary was. And his current salary was based on the employment that he had just started less than a month before the hearing. There was no testimony at trial about what his employment paid when he started in September of 2012, and that how much he made in that employment up to when he started formally working for the Department of Labor. And so the finding that because he was making substantially more, he had mitigated his wage loss was not supported by any evidence in the record, because there was no evidence in the record of what he was making when he worked for J. Douglas Anderson and Associates. The second issue is the board found that, sort of alternatively, that Mr. Prince had failed to mitigate his damages because they found that there was an offer of employment with the state of Kansas in September of 2012, which would have entitled Mr. Prince to benefits. The problem with that finding, Your Honor, and why we assert that that is not supported by substantial competent evidence, is there's no evidence in the record whatsoever of any offer of employment. There's no offer letter, there's no position description, there's no testimony from anybody with the Department of Labor or anyone else with the state that there was an offer of employment made, much less an offer of benefits eligible employment. The only testimony that has been used to support that argument is Mr. Prince's testimony that upon being terminated from the Department of Labor, he received an preference letter that gave him preference for other state employment for a period of 1 year. And with that preference letter, he had applied for 2 positions, one with what was then SRS, and another with the Kansas Department of Health and Environment. The SRS position ultimately was withdrawn, and he was not available to him anymore. And the second, he didn't hear anything about until over a year later, after his preference letter had expired. And then he was contacted, and they let him know that simply the position was still available, but it was the location was mismarked. And at that point, Mr. Prince's circumstances had changed, because he had already accepted employment in Nebraska and had moved. And so that was no longer a viable option for him. And at hearing, he said he refused that position. KDOL has seized on that to try to say that he had a benefits eligible position available to him, and that his refusal of that position constitutes a failure to mitigate.
Well, he did say that. I mean, I'm looking right now at his testimony. He said in that full sentence, to be fair, says, so I would have had to commute from Lawrence to Mayetta to accept that position. And at that time, I informed them that I had employment and I refused that position, period. How are we to interpret that other than that at that point in time, he was offered a position in Mayetta and he refused it because he had already accepted a position in Nebraska?
Your Honor, I think, as I noted in my brief, he gave that testimony without, it was live testimony under examination, without the benefit of being able to go back and scrutinize each and every word. I suspect, given another opportunity, Mr. Prince wouldn't choose the word refused again. But that doesn't change the fact that there is no evidence in the record whatsoever of an actual offer of employment. The testimony in the record is that KDHE contacted Mr. Prince and said the position is still available, the location was mismarked, and he advised them that he was no longer interested in that position. There's no evidence that there was an interview done, that there was an application or any kind of subsequent application or offer made. There's no discussion about what the salary or benefits or anything else about that position in the record. And so our position, Your Honor, is that while the use of refused has created some unfortunate confusion in this case, it's not reflective of the truth in this case or the evidence that's in the record.
Counsel,
You're a little over your 12 minutes, so you might want to wrap this portion up if you want to save your rebuttal. But before you do that, I'll ask my colleagues, do you have any questions that you want to ask Ms. Davy at this
I do
point?
have one that is along those lines. With respect to the dispute you were just discussing, did that dispute really matter since your client testified that he stopped looking for employment with the state of Kansas once he got that job in Nebraska?
I don't know that it does, Your Honor. I mean, by that point, as I said, his preference letter had expired, so he no longer had preference when he was searching for employment. He had mitigated his damages to the best of his ability at that point by finding other employment, and he had moved to Nebraska. So at that point, I don't know that it does matter that he was no longer searching for employment in Kansas.
Well, I mean, does it matter whether he refused the job in Mayetta because he wasn't looking for any job in Kansas at that point? I mean, the dispute about whether he refused the job or didn't refuse the job or whether he was offered one or not, I guess my point is, do we have to pay attention to that dispute because he admitted he had quit looking?
Well, Your Honor, I think the reason he quit looking was because he had found employment. Mr. Prince's position has always been that he wants to be in Kansas. He would prefer to work for the state of Kansas rather than be in Nebraska, because his family is in Kansas. He's always lived in Kansas until he moved to Nebraska. And so his position has always been that he would prefer to be in Kansas, but he was unable to find other employment in Kansas at that point. And so he had already moved to Nebraska. And so his circumstances had changed. And the concern with the argument about the mitigation of damages is if there's a requirement, I mean, if anytime there is a position available in the state of Kansas, if we say you have to pursue any available positions in the state of Kansas in order to properly try to mitigate your damages, it's going to be nearly impossible for former state employees to mitigate their damages because the state of Kansas is just by its nature such a large employer. There are always going to be some kind of positions available. And so I don't think it's reasonable. And part of mitigation of damages is seeking, reasonable alternative employment. I don't think it's reasonable to say that he had to pursue this particular position or, any particular position in order to do what he was, required to do to mitigate his damages.
Well, thank you, Ms. Davy. We will reserve some time for you for rebuttal, and we'll hear from Mr. Griffith now. Once you unmute.
At least you didn't let me go 15 minutes on mute.
Well, I thought at
You may
first
have
maybe
preferred.
it looked like you were moving towards the button to unmute, so I gave you that opportunity. Then when I saw you didn't do it, I thought I'd better warn you. So you
Thank
may begin your argument.
Thank you. As we've noticed or noted, this case is 10 years old, and mea culpa, mea culpa. I mean, the department erred 10 years ago. And when the Civil Service Board said, you're wrong, it was demotion, reinstate him, pay him back pay for 12 months. That's what we did. We paid him. We paid his benefits that were allowed, and we reinstated him. And Mr. Prince, to this day, has yet reported back to work. In fact, even though it's not in the record, under his employment was terminated, I believe it was in 2018, for failure to report work. But we have to remember this is a KJRA case. So there are specific reasons why the district court's decision can be or should be overturned if shown. They have chosen, as Ms. Davies has said, that insufficient evidence or insubstantial evidence and arbitrary and capricious. We would submit to the court that based on the evidence before the board, that there is sufficient evidence to support their decision in this case. And it does refer back to whether or not Mr. Prince mitigated his damages or failed to mitigate his damages relating to his benefits, which he now seeks. Benefits under the Kansas Wage Payment Act are in fact wages and are subject to mitigation just as any other back pay or wages. I think if the court looks at the testimony and the record of Mr. Prince, I don't think the word refused was a mistake. It wasn't on cross-examination. It wasn't a trick question. It was on direct. It was solicited by counsel during his evidentiary presentation. If you look at, as court noted, if you look at how it was used in the sentence, refused means a specific thing. As we have noted in our brief, Webster basically defines it as an unwillingness to accept and uses, for example, a promotion. So it's to show an unwillingness to do or comply. And there, I think you can read easily without being stretching the imagination or interpretation or anything, that there was an offer. There was something that Mr. Prince was unwilling to accept, and that's a refusal. And in doing so, he could have had employment in the state of Kansas, which would have allowed him the benefits that he asked for now. And I'm not too sure, if in all candor to this court, what benefits we're looking at. There would be Capers contributions, which of course Mr. Prince would have to contribute his share of those contributions. Leave, you're only allowed to accumulate so much leave, and Mr. Prince was paid for his accumulated leave. Sick pay or sick leave. So I'm not too sure. I don't think there's really a lot of pecuniary damages that we're looking here. Quite candidly, they would only come into effect if Mr. Prince should either retire or quit the state of Nebraska, come back to Kansas, get new employment, and then work towards retirement. Because if he does not retire, even if those funds are paid into Capers, if he does not retire from the state, he could only withdraw the amount that he pays in rather than what the state pays in. But again, Judge Klein pointed out, does whether he refused or not make a difference because he had quit looking? Again, and one point that has been made several times here in the briefs and in the argument is that Mr. Prince has moved. I've looked through the record, and I don't see where his testimony indicated that he had already moved when he refused the position in Mayetta. And I think that makes a difference, because it's a different, if he hasn't moved to Nebraska and he's just accepted the job and he has a chance to take a job in Kansas, there's nothing to stop him from taking that job, which in fact would have had benefits and would have allowed him to have benefits. I think the board could take a look at and consider his testimony that, and I agree with Ms. Davies. His testimony was, I want to be in Kansas. If I leave Kansas, I want it to be my decision, not somebody else's. But 10 years down the road, he's still in Nebraska. He was offered employment back in Kansas and he didn't take it. So I think the board can consider that. And I wanted to touch on one other thing that we talked about in our brief, and that is whether the status of the issue of the reinstatement. We have to remember, as I said, this is a KJRA case. And so the board can only, as this court on its review, can only act upon what is in the record. And since the reinstatement came after the board's order, the actions of the reinstatement are not in the record. There's really nothing for the board to weigh. Now, that may be cutting into my position on appeal that the board's decision is not arbitrary and capricious. But the fact is, if there's no jurisdiction to challenge the reinstatement at the board level, there's no jurisdiction for this court, of course, to challenge the reinstatement. I most certainly do not want to send this case back to the Civil Service Board, but I do think it's an issue. I think Mr. Prince, once he was reinstated, I think he had to report to work. If he felt that that job was not what the board ordered, it was still a demotion. He could have gone right back to Civil Service Board and said, I've been demoted. They still haven't, I'm still there. That arguably could have invoked the board's jurisdiction. He had the remedies of mandamus to ask the court through mandamus to reinstate him in a position for which he was entitled to by the board's order. He didn't do that. He did try to ask the district court to enforce it under the KJRA, but the court correctly ruled that only the agency or an agency has the ability to enforce a administrative order under the enforcement provisions of the KJRA. So I think I think the result is the same. Mr. Prince took made no effort to preserve his employment or to enforce the board's order through proper channels, and therefore I think that issue is gone.
Mr. Griffin, before you go on, let me ask you a few questions just to clarify.
Sure.
What exactly has he been paid at this point in time relating to this case?
What has he been paid?
What is he? Yeah, what has he been paid? I think I heard you say that he's been paid for 1 year of salary.
Right.
Or past wages.
Yes, his back wages for that period are allowed by the board. Any accrued but unused pay.
Up until what date?
Well, for that same period.
Oh, okay. Okay. So
Yeah.
for that 1 year.
Right. Basically what the board did is they allowed the damages or remedy for everything for the same period of time. Basically from the period of time when Mr. Prince was laid off at the department, which was several months later after the demotion, until he took new employment in Nebraska. He worked in Nebraska as for the Department of Labor in Nebraska as a contractor, an independent contractor before he became an employee. So there's
so he didn't receive benefits initially because he was a contract position, and then he subsequently did.
Right.
Okay,
Right.
so you heard Ms. Davy indicate that there's nothing in the record to show that Mr. Prince was actually offered the position in Mayetta.
Uh-huh. Yes,
Is that accurate, or is there something in the record that shows that he was actually offered that position and he could have reported to work, showed up one day and said, "I'm here to work"?
I think you read, I think it all kind of boils down to that sentence that we're talking about, where he indicates that he refused. Is there a statement in the record that Mr. Prince, we are offering you this job, do you want it? And I will be completely candid with the court, and no, that is not in there. The question is there sufficient evidence from the record for the board or a reasonable person to come to the same conclusion as the board based upon that evidence? The evidence that in the record is that the state of Kansas contacted him about that job, and he indicated he refused the job. You have to have something to refuse. He didn't testify that I withdrew my application, or I didn't. He didn't testify. I told him I changed my mind. He testified he refused the position, and our argument is from the evidence that is sufficient for the board to reach the conclusion that he was made an offer and he refused it. As the board indicated, also, however you look at it, he clearly cut off the possibility of obtaining that employment with the state of Kansas. And that's basically, unless the court has questions, I think the rest of it is just a rehash of what's in the brief.
Appreciate that. Do my colleagues have any questions? Okay.
Thank you.
Well, thank you, Mr. Griffin. We'll go back to Ms. Davy for her rebuttal.
Thank you, Your Honor. I do want to touch on just a couple of things very quickly. Mr. Griffith indicated that Mr. Prince refused to report to work when he was reinstated. That is not accurate. Mr. Prince tried to work something out with the Department of Labor to return, and we have tried multiple times to have discussions or have a hearing with the Civil Service Board regarding whether the position that he was to be reinstated to complies with the board's order. And our position is that it doesn't. The position description that we were provided has substantially different job duties, despite the board's order that he be reinstated to a position with the same or similar job duties.
So is this just to make sure I understand your argument? Is this the position in Mayetta?
No, Your Honor, this is the reinstated position.
Okay, this is the, okay.
After
I understand. I just want to make sure I knew which one you were talking about.
Sure, and thank you for clarifying, Your Honor. Yeah, our position is that this the reinstated position that he was offered does not comply with the board's order, and we have requested a hearing with the board to try to flesh that out, to get some more information in the record. And Mr. Griffith is accurate. There is very little information in the record regarding this reinstated position, and that's because at every opportunity we've been denied the ability to have a hearing to put evidence on the record. Likewise, there's a lot of confusion about or speculation about this issue with the use of the word refuse, or whether Mr. Prince had already moved to Nebraska or not. Mr. Prince has tried to clarify the record. He submitted a declaration at one point, both to the district court and to the Civil Service Board. We have requested a follow-up hearing to try to clarify some of these issues and get the truth before the Civil Service Board, and again, have been denied at every opportunity. And so to the extent that there are still questions regarding the findings of the Civil Service Board, that's certainly not for a lack of trying to clarify on Mr. Prince's part.
And even though there's still open questions on some of this, it seems to me that we all need to focus on what are the material questions. And I think perhaps because this case has dragged out so long, some of these questions may not really be all that material from a practical perspective for either party. So in any event, go ahead. I understand that there are some open questions, but I really want to focus on, if I understand it correctly, and I thought I did, and Mr. Griffith at least clarified what I thought was the case, that Mr. Prince has already been paid for that 1 year past wages and for whatever accrued benefits he would have had during that period of time at least. Is that correct?
Mr. Prince was paid for the wages, most of which was promptly recouped by the Department of Labor for an unemployment lien. But
again, that's not really material to our issue.
that's a separate
So
issue.
let's focus on ours. Help us out. Help us.
Well, and Your Honor, I don't recall right offhand if he has been paid for the accrued vacation and sick time that was ordered by the board. My recollection off the top of my head is that Mr. Prince was paid when his employment ended for what he had accrued at that point, but I don't recall that there has been a payment for what the Civil Service Board ordered in that additional year of accrual. But
I think we would all agree that he's entitled to that. I don't think that's what I'm trying to figure out is what really remains. Let's say you win hook, line, and sinker. We send it back. You win again at the board. What is a practical matter is the expectation of what you're seeking here,
well,
in
Your Honor,
addition to what's already been paid?
Well, Your Honor, there's another 5 years of sick and vacation accrual, 5 years of capers, contributions, 5 years of the value of his health insurance. Mr. Prince was legally required under the Affordable Care Act to have health insurance, and so he had bought that out of pocket. And that was evidence of that was presented at hearing, and we asked for reimbursement for those expenses, and that was not granted as part of the order. So there are actual health insurance costs that would be part of that order. There was longevity bonuses that he was going to be eligible for. I mean, it is not an insubstantial amount of benefit accrual that is at play here. I'm
not trying to question whether it's substantial or not. I'm sure it was substantial. I'm trying to figure out exactly what the end game is here, because the law favors bringing cases to some type of end. The law also favors settlement, and I'll just throw that bone out to both of you while you're here this morning, because at some point it seems like it would serve the state of Kansas and Mr. Prince to get this over with. But what I'm trying to figure out that now from we can't decide that, but what we can decide is do we need to send it back? And if so, are we just simply spinning our wheels, or is there a purpose, a material purpose to do so? And what would your best argument as to what's the material purpose for sending this back to the board yet again?
Well, Your Honor, I think our preference would be, the Judicial Review Act authorizes this court to enter a judgment, and I think this court is empowered to enter a judgment for the accrued benefit loss that was reflected in the record. And so our preference would be that there be a judgment entered.
But you said there's all these fact questions out there. We're not a court that can resolve facts. Some of us used to be, but not anymore. So don't we have to send it back if there truly are these factual issues?
Yes, Your Honor. And that was our alternative remedy request, was that this be remanded to the Civil Service Board again, with the specific direction that they have additional hearings to determine the evidence on some of these issues. If there are still questions of fact regarding whether there was an offer of employment, whether Mr. Prince had already moved, what the specific job duties are of this reinstated position, then that needs to be, Mr. Prince needs to be afforded an opportunity to present evidence on that, and the board needs to have that evidence to make those decisions. Otherwise, that goes directly to our argument that the current findings of the board are not supported by substantial competent evidence, and they're otherwise arbitrary and capricious because of that lack of evidence in the record.
Well, thank you for your arguments. We'll take this. Well, I assume my colleagues have no questions. Okay, we'll take this case under advisement and try to get an opinion out to you as soon as we can. And remember, the law favors finality and settlement. So with that, Rock Chalk Jayhawk.